Calling our next case, Pinsky versus Kroger. Good morning. This is a 15-minute mini oral argument on the application. You have two minutes of a free fire zone, and you may reserve time if possible. And you can begin when you're ready.
I'm just trying to get the podium right.
Yeah.
May it please the court, Steve Hicks on behalf of the plaintiff appellant, Dr. Renee Pinsky, and her husband, Dr. David Pinsky, who has a loss of consortium claim. I will waive the free fire zone. I would like to reserve 2 minutes for rebuttal if I can try to do that. And I would welcome the court's questions. I, of course, had some ideas about what I could tell the court. It was pretty consistent with what prior counsel said in the earlier case. I think we're on the same page, that I think the restatement towards third is the most consistent with the comparative negligence rules that we have in Michigan in that framework. So if I can just jump to some of the questions that were asked. In particular, Justice Cavanagh, you asked a question towards the end there. You said to defense counsel, what's special about premises? Historically, what's been special about premises is that it creates a heightened duty for invitees to protect against these unreasonable risks of harm. The question that you asked earlier, and that's been ameliorated by Lugo, that duty no longer exists. But the earlier question that you asked, when you were focusing on restatement towards third in particular, you were focusing on the fact that restatement towards third looks at risks that are posed, whether they're created by the possessor of land, whether they're artificial conditions that exist on the land, or whether they're natural conditions that show up on land. The language does, and you're correct in this, does use the term risk. It doesn't use the term unreasonable risk of harm. And the reason that is because the whole shift in restatement thirds is, towards third is to a breach analysis. Basically, the reason there isn't the unreasonable risk of harm, and this is to the benefit of the defendant in some way, there's no longer the heightened duty either. There is simply reasonable care that's imposed on both sides, both parties. The plaintiff has a duty to use reasonable care. We assess that in cases all the time right now because we are a comparative negligence state. And I have to say that I've always been a bit baffled by the notion that, and this goes, I think, to Justice Welch's question, is what would be the duty? What would you have to do? What are businesses supposed to do? They need to use reasonable care as well. It's not that hard to assess. It is fact-based, it is fact-driven, and I think you got to this in your later questioning about insurance companies needing to do this all the time. They have to assess what a business should do. So is there anything special about premises? Well, there is if we adhere to the restatement towards second, and we truly had a heightened duty that was owed to invitees in Michigan. But that hasn't existed since Lugo. What it's similar to, and the reason that it's really not special, and the restatement towards doesn't treat it as special, is it's much like our ordinary negligence cases. I mean, we've been fighting these battles since Lugo became the law in Michigan. We've been fighting battles over, in fact, I think one of the last cases I argued here was is it an ordinary neg case, or is it a premises case? If it's a premises case, I was out. I lose on open obvious. If it's an ordinary neg case, then we go back to the trial court, and frankly, we hash over whether a duty was owed, as the court said in that case. That's Scola versus J.P. Morgan, if any of you recall it. It's been a few years. But that's a perfect example of the analysis that needs to be done if you go to restatement towards third.
So counsel, obviously you had the benefit of seeing the exam first. The same questions I had. I mean, I think there is this sort of concern, societal concern about frivolous lawsuits. You know, there's nothing wrong with the property and someone trips and falls and they sue. So is that What happens in that case?
C10, you're out.
Okay.
If it's an ordinary step, and there's nothing wrong with that step, first of all, hopefully the lawyers aren't bringing that case, but we have to all recognize that there are going to be some of those cases that are brought.
Are they all
regardless.
C10 or some of them C8?
Oh, I think there can definitely be C8 motions as well. In fact,
Can you think of an example?
I'm facing a C8, C10 motion on Scola, which was a case I argued, 4 years ago here, which the case was kicked out on open and obvious, it was considered a premises case based on what was alleged. But we're back in the trial court on an ordinary neg claim because that's what this court decided. And now we're facing a C8 and C10 motion.
But is it, you obviously don't want to speculate on your own case, so I don't want you working
I like
against.
to think we'll
I
win,
don't want
but-
you to work against yourself. So I am wondering if there, I tend to understand that there's a factual issue if something's wrong with the curb or something's wrong with the step or the circumstances surrounding it. But I am wondering about something, there's nothing wrong with it at all. And the defendant was just not looking. They were texting on their phone and they fell down the steps. Does that go to C10?
Well, the focus isn't really there. It really, those things would all factor in to what the result would be in the case. Certainly, the higher the person's comparative, their damages are
Right, but
taken
that's
away.
still
But-
saying it's.
No, that's why I'm saying the focus is really on what the defendant did. There certainly are cases, and I've seen cases recently, where there was found to be no breach. I don't have an example off the top of my head in the premises context, but I lost a case just a few weeks ago that dealt with, in the auto context, of someone that was in the roadway and a driver that did not see them and hit them. They found that there was no case there, and that was affirmed on appeal.
Is there some, I guess, and I appreciate the difference. I think the practicality of, why are we trying to even avoid a C10, right? C10 is there. C8 is, I'm saying you owed me a duty. You don't own the property. You don't exist there. It's not a condition on the property, it's your conduct. There's any number of C8s,
Notice.
right, that are bases for a C8. But for a C10, I allege there's this condition on the property, a curb, but until I've got the facts that show curb was totally fine, I was looking at my phone, I didn't look at it, that's out on C10. Isn't that okay? It should be out on C10, and if there are facts that come to light of, the curb had razor blades or it was moving or something like that, or, that say, no, what, maybe defendant wasn't reasonable, maybe plaintiff was reasonable in encountering it.
I think you're out on C10. I think you can't establish that there was a breach of duty. It's exactly as you pointed out. There were two cases, really, when Bertrand was decided. It was Bertrand versus Allen Ford, and it was Maurer versus Oakland Park Department or something. I can't remember exactly what it was. But they're dealing with two different issues, two different steps. The Bertrand one was oddly configured. The other one was not. One of them, the plaintiff got past summary disposition. The other one, they did not. And that's exactly what the analysis should be. While I'm speaking of Bertrand,
Let me just jump in, because I'm looking at this statement in Riddle. Once a defendant's legal duty is established, the reasonableness of the defendant's conduct under that standard is generally a question for the jury. So based on the discussion here today, that statement is an incorrect statement of the law. It's not generally a question for the jury. It might get to the jury.
Under Lugo, it's certainly not. And we could talk about Lugo, the case, and how it analyzed.
Well, that
and created
Lugo, it says, once a defendant's legal duty is established, you're here saying, we want the restatement third, which says everybody owes a legal duty to everybody else all the time, duty of care, right? That's, restatement third makes this sort of, in my mind, nonsensical, all-encompassing, assertion from the dissent in Paul's graph that doesn't really answer any of these questions. But if we accept that there's always a duty, now I'm trying to understand the reasonableness of the conduct, defendant's conduct, is generally a question for the jury. I just want to make sure I can.
Yeah, let me address that duty question directly, and because I don't think it's nonsensical at all. In Paul's graph, we were talking about attenuated actors and whether they could be brought in. in the premises context, we are talking about the possessor of lands.
I say nonsensical
obligation.
because it's true, but it's like a truism. I mean, it doesn't help us answer any of the legal
Well,
questions.
the truism is that everyone should have a duty to use reasonable care. We should all be responsible. The plaintiff should be responsible every time they walk in. But under Lugo, the defendant's responsibility, in this case duty, evaporates unless you can establish, and unfortunately this is what it
Well, you
has-
don't like the special aspects, I get that. I think
Yes.
the special aspects, as you might have gotten from my question before, have caused some problems. I think, I don't want to speak for others, but I think others might think that as well. The question is what to do about it, and
I agree.
And changing this analysis entirely and taking it out of duty would be a major destabilizing shift in our law, and I'm
On that
trying to
point, I disagree.
understand, hold on, I'm just trying to understand the,
Apologize.
you know, there's some discussion about that's the cause or a result of Lugo, that this has been analyzed as part of the duty element, but that's not true,
No.
is it? This goes back at least to Riddle, where this court examined the precise question of whether analyzing this question in the duty element was consistent with comparative negligence principles, did we not?
Did. And
Are you asking us to overrule Riddle?
I believe that Riddle should be overruled.
How many
because it's
cases are you,
inconsistent.
how many cases are you asking us to overrule here? Is it like a dozen, or going back
No.
100 years, or just a couple, or?
Not at all, Your Honor. 100 years ago.
We'd have to do
When he talks about
Bertrand?
100 years, he's talking about contributory negligence years. I think we've moved beyond that in Plasek. So I don't think we have to go back and say, well, geez, if we weren't clear, let's overrule Plasek. But with regard to Riddle, let me be
Well,
absolutely
for
clear
100
about
years,
the
we
problem with Little.
followed the first restatement, and then we followed the second restatement. We've said that many times. The second
did until we
restatement is
didn't.
pretty much consistent with the first restatement. I mean, the law's it's been pretty clear for a long time. Up to Lugo, and I think Lugo may have caused some problems, but
Yeah, you are correct that we followed the second restatement towards, until Lugo, until we didn't. We in theory followed it in Riddle because of we adhered to 343A. We followed it in Bertrand and applied 343.
followed it pretty closely in Livings.
Well,
I would say.
In Livings, we backtracked, I would say, and said, hey, let's breathe life back into 343A. You can do that in my case as well. I've given you an illustration that shows, just like in Livings, there's an illustration, deals with distraction. You can apply that here. But what we're doing is we're taking what is effectively a contributory negligence rule under Lugo, and we're chipping away at it with little last year clear chance exceptions where the result is too harsh. And the question before the court today is, I really think it's the one Justice Clement asked in her dissenting opinion in Livings, which is, what framework works? And what framework works is the framework that the legislature gave us. When Riddle was decided, we were a pure comparative fault state. We had become that in '86. After Riddle, we changed it again, and we gave the defense more ammunition, because now if the plaintiff we moved to a modified comparative fault. Now if the plaintiff is more than 50% at fault, they lose their non-economic damages. They can only get economic loss. What is consistent with that system? And what's consistent with that system is, the most consistent, I would say, is restatement towards third. You can make it somewhat consistent. You can keep putting that square peg in that round hole by going back to restatement towards 343A.
What do we do with the
But
statement?
the reality is it doesn't work.
What do we do with the part of the restatement third that says there could be exceptions on a case-by-case basis if the judge thinks for some policy reason there shouldn't be liability? How does an insurance company allocate risk? How does anybody know what their obligations are until we have decades more of development of common law judge decisions so that property owners know what their obligations are under the law?
Yeah, I view that sort of like the I'll know it when I see it sort of provisions, or in the interest of justice provisions. There may be this rare case.
We agree
In
on
my
that.
my experience, those are never applied. You know, show me the cases where someone actually says, gee, I'm going to go to the catch-all, and I'm going to breathe life into the catch-all provision.
Wait, but
The reality is it
that
doesn't
benefits the plaintiff, huh? Because there'll never be an exception under
Well, the
the,
plaintiff's going to make arguments. They'll make arguments.
no, that's the defendant's argument.
Well, the
They'll-
idea that I think, or at least stated, I think specifically stated in Lugo, is that this standard will make it so clear, and we won't have litigation. And it's, I mean, all we did is shift the litigation, right? We're not
the appellate
saying,
courts.
we're now shifted the litigation to, what does it mean to be unreasonably dangerous? What does it mean to be effectively unavoidable? What is all of that? And I guess, I mean, assuming that that's I guess it is a consideration for us in fashioning the common law of what that will be. But like, so, I mean, does that mean if we shift, whether it's a tweaking the square peg of a round hole, into a round hole with the second, or adopting the third, or something somewhat in between, does that really mean that everything goes back to a jury? Or does it mean?
Oh, I don't think it does. I think certainly we will face C-10 motions. And I would analogize this to, for example, to Kreiner. I mean, after McCormick came down, everybody thought, well, gee, it's always going to be a fact question now on serious impairment of body function. That's not our experience now. There are many motions that I'm seeing all the time on serious impairment, and there are certain categories where it will succeed and where plaintiffs are not building the right record. The same will be true in premises. The fact that a standard is fact-based and uses a reasonableness test, that alone doesn't mean that it's unworkable. It just means you're not going to be able to put everything in a nice little bucket. Here, you're this, your ordinary neg or your prem, your invitee or your licensee. Your duty is this, your duty is that. All it does is create litigation. What the restraint towards third recognizes that nationally we have shifted to comparative negligence. It is an embodiment of that shift, a shift which occurred in Michigan many years ago before we deviated in Lugo to a standard that no other jurisdiction uses.
Counsel, I know your time's up,
I'm
and
way
I
over
think we
time.
still have questions. So
I'll stay as long as you want me to stay.
I'm still, I'm going to admit, I'm still stuck on C8, C10, and this frankly gets to Justice Clement's statement in Livings, where it's obviously a lot of confusion over what's the judge, what's the jury. I'm still sort of troubled by the notion that there can be absolutely nothing wrong with the property at all. And the pleadings, it's just steps. I fell on steps. There's nothing in the pleadings that says there's anything wrong with the steps. And that, basically, are you saying that every case gets full discovery? I mean, is that where we are? Every slip and fall, we have to do discovery?
No, I mean, if I were defending that case, if I were in the defense's shoes on a case like that where I really believe there is nothing wrong here, I would move for summary disposition early because there's nothing that says you can't move for summary disposition early. And that would force the plaintiff to come forward and say, no, I actually have something here. Here's my expert. Here's some testimony. Here's some pictures. Here's some this. They have to do something at that point. And you can bring that motion at any point in time. Also, there are many grounds for summary disposition in premises cases. Notice is one of the biggest ones that we see all the time, and this court has addressed issues of notice. And that's another defense that is often, you're going to see motions on that, and a lot of them will be successful. So there will be fewer C8, there will potentially be more discovery, but certainly there will be cases where the plaintiff just, all they have is an injury, and they don't have any real risk that was posed, other than, you should have been paying attention.
Counsel, I appreciate your arguments today, and in Scola, I feel compelled to just clarify that not everyone up here agreed that was an ordinary
That is true.
case.
That is true. But I thought I'd tell you where it went.
I was interested. I listened with and I'll be interested to
They're
hear
still fighting me on duty in that one, which is
Right.
what I think you wanted them to do. So
I'll be interested to hear the end of the story.
thanks for your time.
Thank you.
I can check, it's still morning. Good morning. I'm Nancy Dumbinsky on behalf of the appellee Kroger in this case. And I feel like all the thunder has already happened with respect to arguments that can be made on this issue. So I'd like to take this opportunity, I guess, to at least point out that in looking at the open and obvious rule, I've heard it say that it's an exception, but it's really the scope of duty, I believe, is how it's intended. I believe scholarly articles have referred to it as that. The scope of a duty for an invitor does not include an open and obvious condition when viewed objectively, because the possessor of land and the customer are both essentially on equal footing to realize the danger posed. It's not a subjective inquiry, it's an objective inquiry looking at the property. I don't know how much of this bench just agrees or disagrees with that, but I think premises liability has always started there, even Riddle, even Bertrand. And I read specifically Justice Michael Cavanagh's opinions. He concurred in Lugo. He wrote Bertrand. And I think his point was to, again, look at the restatement, looking at duty, again, from that objective view, which Riddle took to task. In Riddle, both sides, both the majority and the dissent, agreed that 343 and 343A do not present a problem with respect to comparative negligence. I believe former Chief Justice Cavanagh mentioned that it wasn't, or it could be compatible too, in her concurrence in the Blackman case and in talking about livings. I think livings with Justice McCormick's concurrence is where that 100 years of law comes in. I read that too. I didn't do all the research going back 100 years. She did that, and I read it because everybody in Michigan reads it. To find out sort of where does this stem. I think the question was, where did it originate? Where has it wound up? And with respect to the open and obvious doctrine, again, first we're looking at the premises objectively, and both sides, is there any question on whether it is open and obvious? And I realize it's the special aspects that the bench, both in the discussions in livings and elsewhere, have mentioned on, was it too narrow in Lugo? And I think Lugo is not inconsistent with the restatement. It was trying to give the trial court examples, and maybe those hypotheticals have been harshly construed. What I'd like to remind the court, though, again, the author of Bertrand, when looking at the ordinary step or what's unusual about this circumstance, concurred in Lugo, in as much as the law was not changing.
Can I ask you, though, I think, I understand that, and I think, and this was maybe inartfully what I'm trying to get to on the issue of unreasonable risk of harm. That has been the standard that's adopted from the second restatement, right, at least since Riddle, perhaps before. Unreasonable risk of harm, I sort of view that as a gateway, right? Like the duty extends to an unreasonable risk of harm. A curb doesn't present an unreasonable risk of harm, right? I think the problem with that, and perhaps the regular stairwell in Bertrand, is this open and obvious special aspects Lugo has been like, everything has to fit into that round hole no matter how square the peg. And so we lose that. Why can't it be that if the standard is an unreasonable risk of harm and you bring a case on with a plain curb or the first set of steps in Bertrand, you're out on unreasonable risk of harm, right? Like without going to open and obvious in Lugo and was it special aspect? And maybe part of the problem is there's this imprecise wording between unreasonable risk of harm and unreasonably dangerous in some of the other circumstances, right, or some of the other cases. And I think even some of the, opinions of this court have recognized that perhaps the words that have been used not very carefully. So why is that, like, if Lugo and the problem of special aspects is, changed or clarified or taken care of, doesn't the unreasonable risk of harm at least still exist? And, you're not, a premises owner is not responsible for every risk of harm, but it could be an unreasonable risk of harm.
Well, I think the open and obvious doctrine as it stands is consistent with that, in as much as it's saying that if a condition of land is observable by a reasonable person on casual observation, it's not unreasonable risk, but it could be a more dangerous risk, as Lugo says, when there's an extreme risk of significant harm or death. Like you said, steps may have a risk of harm because people falling down the steps, that's not a good thing. People can get hurt. With an open and obvious hazard, again, when viewed objectively, persons aren't expected to encounter those dangers because they don't risk themselves, and the premises owner is not held responsible for that because they do not anticipate that harm.
Except counsel, in this case, you had a person that tripped over a wire. And isn't that something that is appreciable as a risk? You know, that's the kind of concern that kind of develops as a result of this, is that not everyone's going to, when you're walking through an aisle, is going to assume that there's going to be a risk in there, especially a low wire. That's the challenge, isn't it? Is that it's not, the challenge is that it's something that you're not anticipating, right? You're walking into an aisle, you're not anticipating there's going to be a wire in the aisle. And that's where this gets to be concerning, because ultimately it makes it so that the premises owner isn't really having to be concerned about that.
Well, that, again, is subjective weighing. What I'm trying to articulate, and obviously not very clearly, is looking
you're
at
excellent.
looking at the duty aspect from an objective standard, whether the hazard was visible, whether it can be seen, is different than whether the hazard was expected. Because when you have someone going the wrong way up a shopping aisle and there's no cashier there, and the aisle might be closed off, people are responsible for looking, but again, from my client's position, it was not foreseeable to them that people would walk through it. I mean, the reason they put it there is so people wouldn't walk down that aisle.
But even if yours, even all of this aside, tell me why there's not a question of fact in your case that maybe it is reasonable to expect that what everybody or what most people see is closing the lane of a grocery store with a, canvas strap across from one side to the other or what have you, maybe should be anticipated. It's obvious, you can see it, you're not expecting, that owner shouldn't expect that somebody's gonna confront it anyway. But here, there's at least the fact, and there's a picture that might substantiate that, of a thin wire at about mid-calf, right, or ankle sort of.
It's not at ankle.
Well, okay, mid-calf or somewhere below where the normal thing would be. Well, there's a picture that suggests that, and it's attached to a stand of baby formula with pictures of babies on it, and maybe they lose. I mean, maybe a jury says, no, I'm sorry, you should have been able to see that, I could have seen it, I would have avoided it, fine. But isn't that a question of fact of whether or not a reasonable person should have seen that?
I don't think so, because there is no reason why a reasonable person couldn't have seen that. You're approaching a lane that has a closure with a white wire across it, and the height is in dispute, I think. But as far as looking towards it, this is it's a disability accessible lane. That's why it's so wide. So where the wire is placed through the stand, I would also point out that no one has ever said that that was distracting. I think that that was one of the questions that we were asked to brief about. No one has said that they were distracted by the babies on the baby formula. It was argued, Renee Pinsky never said that. She basically said she acknowledged that there was a basket and she thought it was baby formula, but she acknowledged it as if you're aware that there's a picture on the wall, but you're not focusing on it. Those are her words in the transcript. So again,
So is it your client's position that the picture that's submitted is not an accurate rendition of at
I
the
don't know
time of
what
the injury?
picture you're referring to.
The picture that was in the brief and in the
There's
appendices?
several pictures in there.
Okay. So you contend, I mean, But isn't that, if one side says this is what it looked like and the other side said, no, it looked like this, isn't that a question of fact?
What we are arguing is that the way that it was set up, no matter the height, you cannot, as a reasonable person, encounter that and not see it on casual inspection.
No matter the height.
No matter the height. And as this court knows, I mean, there's snow and ice cases, there's puddle cases, there's pothole cases. Those are floor level cases. So again, a person, when they're viewing where they're going, are looking at the whole course of where they're going. And here, again, the intention was to close this off so persons weren't entering this particular lane. Again, looking at it objectively. If there was a question on whether it was objectively under the law as it currently stands, then there'd be a question of fact. We're arguing there isn't, and that's what the Court of Appeals found, and we agree with them. You don't have to make a change in the law to come to that conclusion. That would be very factual specific in our particular case. As it pertains to the third restatement, we would just argue that adopting that would be a major upheaval in the law in Michigan. I know this court will look at it stare decisis, but I think just based on the concurrence in the Livings case by Chief Justice McCormick at the time, premises liability is treated differently, products liability is treated differently, medical malpractice is treated differently. Municipal cases, there's a statute, so that's treated differently.
Right, all those
also.
examples actually have statutes.
Right, and as a matter of fact, the open and obvious doctrine has been subsumed partially in a statute with respect to the exception to governmental tort liability. So
Well,
here.
it's also phrased in terms of the common law.
It is.
Right?
It
Common law
is.
defenses, and common law is uniquely within the realm of court, right?
It is,
Okay.
absolutely. Not arguing that, just saying that
Yeah.
the legislature has looked at the common law, at least in that respect, in speaking to the open and obvious danger doctrine at that time. We believe that the second restatement, I guess, has done its job as far as it has statuses of premises users. That seems to have worked for the state. There's reasons for it. As it pertains to invitees in particular, this has been the law in Michigan, and open and obvious, again, I believe goes to the scope of the duty because of the fact of its obviousness when viewed objectively. We aren't viewing that piece of the puzzle subjectively as you would other ordinary negligence cases. I can't believe I'm running out of steam here, but.
I just have a question, though. Based on your argument, if this doctrine were to change, the argument seems to be that it's going to be very difficult for people to appreciate or understand the risk. Why is that? I mean, ultimately, isn't it just the incentive for your client to always kind of keep the store safe, keep the premises safe? Like, what about this would appreciably change so that if this doctrine were to change, the argument seems to be this would create an upheaval? Why is that? Like, doesn't that ultimately go to the argument that, well, people like it this way because they don't have to really appreciate the liability? I mean, it's just an interesting perspective, which is if your client wants to maintain a safe facility, if this doctrine were to be changed, why would this be such a problem? Is it going to change how they do things? Is it going to change how they operate? Is it going to change how they clean? Is it going to change any of the ways that business is done?
I don't see it as changing the way business is done with respect to, as it currently exists, stores don't want people falling down. I
Right,
mean,
exactly.
They're not incentivized. The law might help to incentivize, but they also want people coming back. I mean, if you're a store that's got stuff broken all over the place and stuff on the ground, people aren't going to shop there.
Right,
And I
so
don't
that
think
isn't
any
that-
store wants that.
But no, doesn't that go to kind of what my point is or my question is, which is that ultimately, if open and obvious, if the doctrine were to be modified, would it really change how businesses function and operate? Because based on what you're saying is this is how you function and operate. You keep it safe, you keep it clean, you want people to come back, you want them to have a good experience. So why, what would be the harm if the doctrine were to be changed or modified?
I realize my time is up, but if I could
Please,
answer
please,
the
please.
question. I believe it is because, again, with respect to open and obvious dangers on the property, our case was one where an employee closed a lane. There's people that drop stuff in a store.
Right.
There's snow that happens in a parking lot that, when a snowstorm comes and your snow removal contractor, can't get around parked cars or things like that. How I think it would change is because, again, the open and obvious doctrine allows store owners to realize, as the law currently stands, they are not the insurer of everybody who enters the store. Risks can lie there. It's the unreasonable risks, I think, that have been the focus. And when things are open and obvious, they are not held to pose an unreasonable risk unless there's certain conditions. As Bertrand said, there's something wonky about the
But
stairs.
wouldn't you want to correct the risk? I mean, ultimately, doesn't the incentive go the other way, which is as a business owner, wouldn't you want to correct that risk or make sure that risk is not apparent? So, because the more open and obvious is, the easier it is for the business to ultimately correct it, right?
I think that a business is going to correct the risk irregardless, personally. Because again, it's not good business to have people falling down or
Right.
to not change things. I mean, I think that goes to subsequent remedial measures, which isn't necessarily, the argument here today, but just because there wasn't liability for something doesn't necessarily mean the store owner's not going to change it. I think they would, because they don't want to see it happen again, because then that goes to notice, as council brought up. Now you're on notice that people are falling down all over the place. And perhaps before there wasn't an awareness of that. Different aspect, but that would be how I would answer that. No matter whether or not the obstacle is open and obvious obstacle, I don't believe the store is less incentivized to make it so that it doesn't happen again, if that makes sense.
It does. Thank you, Council.
Thank you.
Thank you. The case will be submitted.